Our speakers today, I am very thrilled to have. They are all top experts in this field and should be able to answer, hopefully, all of your questions. So we have Linnette Attai from PlayWell LLC, Bill Fitzgerald from Common Sense Media, Sara Kloek from the U.S. Department of Ed, and Lydia Parnes from Wilson, Sonsini, Goodrich, and Rosati. To kick us off today, I want to start by talking about FERPA. So if Sara doesn't mind being the first subject of our questions. So as most people on the phone know, the primary federal statute that governs student privacy is FERPA. So Sara, can you talk about FERPA and its restrictions, if any, on advertising?
Sure. Yeah, Amelia, you can hear me now? Hello?
Yes, we can hear you.
Okay, perfect. Hi, everyone. Good afternoon. My name is Sara Kloek, and I am the Senior Privacy and Technology Fellow at the Department of Education in the Office of the Chief Privacy Officer. And I am going to add a little disclaimer in here, just saying that these are my views and don't necessarily represent the views of the Department of Education, just because that's a good thing to do. So at the department, we oversee actually two different privacy laws, which Congress passed into law in the 1970s. So they have a rich and long case history. But I know we're talking today about the intersection of Ad Tech and EdTech. And given current technology, we do recognize that there's a fine line between personalized learning, content recommendations, and advertising. We don't have guidance specific to advertising technology, and like I mentioned before, since these laws were written in the 70s, advertising technology was a lot different. We learned this on the call, what was that, a couple weeks ago, that advertising technology has changed a lot, even in the past decade, and will continue to change. So we don't have, like I said, we don't have specific guidance on advertising technology, but we do have some guidance on educational technology, which I've linked in the Google Doc today, and you can also find it on our brand new website at studentprivacy.ed.gov. But I'll just give a quick basic and brief primer on these federal student privacy laws so we can have a kind of larger context for the call. And I do want to mention that, so first law is FERPA, the Family Educational Rights and Privacy Act. This is the federal student privacy law that most folks are somewhat familiar with. This puts requirements on public schools, K-12 schools, and also most public and private colleges and universities to protect the privacy of students' education records and also to give parents and eligible students access to those records. We acknowledge and know, everyone knows that schools are using a lot of different technology in and outside of the classroom, and some of that technology may need access to student data to perform that service. There's a couple ways in which schools may disclose data from education records. So I want to go over those first because that kind of will help us think about advertising technology and education technology. So one of those being schools can get consent to disclose information from the students' education records. That consent is pretty basic. It needs to be signed and dated. Needs to specify which records may be disclosed. It needs to note the purpose of disclosure and identify the party or class of parties to whom the disclosure may be made. And then secondly, again, if a school is going to disclose information from a student's education record without consent, either from the parent or the eligible student, they can use the school official exception in FERPA, which is pretty strict on what and limited in when a school can share data without a parent's consent or eligible student. An eligible student is a student that's 18 years old or is enrolled in post-secondary education. So there's 4 separate points that a company must meet in order to get access to a student's education records, whether it's a limited amount of data from the education records or a larger set of data from the education records. So the company needs to perform an institutional service for which the school would otherwise use its own employees. The second point is that the company must meet the school official criteria set forth in the school's annual FERPA notice and has a legitimate educational interest in the records. Third is the information from the education records shared with the company are under the direct control of the school or district. And fourth, the company may only use the education records for authorized purposes and may not redisclose PII from the education records to other parties. We know that there's also some educational services that might not use PII from education records, so FERPA wouldn't necessarily apply here. An example of that would be a class visits a popular magazine's website to learn about hummingbirds and watches maybe a few videos on that website. Since no specific PII from a specific student's education record would be shared, FERPA would likely not apply. Personalized learning, content recommendations, and targeted advertising. So it really is an issue. I can't go out there and say yes or no. But we generally don't consider the use of student data for advertising to be under the legitimate educational interest, and as a best practice, do not recommend that schools allow the use of PII for advertising in their contracts with companies. A school would not be able to share data with a provider that uses the data for online advertising because under the school official exception, there would likely not be a legitimate educational interest. And then briefly on the second law is the Protection of People's Rights Amendment, PPRA. That law is a law in which that gives parents, it's only directed at K-12 schools, and it affords parents certain rights when information is collected from children, including for marketing purposes. There are a bunch of exceptions, and I think it might make this call 4 hours long if I go into PPRA in too much detail. So I do want to refer people again to our Protecting Student Privacy document that I've linked in the Google document. And I am happy to answer questions later.
Perfect. Thanks so much, Sarah. Really appreciate it. And as a reminder for those who have joined us, please, if you're on the phone, email me to let me know that you're on, so we send you the follow-up materials and the recording. And if your name is not recognizable on the screen. And all questions should be in the Google Doc, tinyurl.com/adtech-edtech. So now we're going to turn from FERPA and PPRA, at least for the moment. If you have additional questions, feel free to stick them in the Google Doc and we'll come back to it. So in addition to FERPA and PPRA, the FTC enforces a rule focused more generally on children's privacy. Lydia, can you provide us with a general overview of the rule, including its purpose and main requirements? You may be muted, Lydia. Oh, there we go. All right, Lydia, go ahead.
Okay. Can you hear me?
Yes, we can hear you.
As they say, can you hear me now? Okay.
That commercial is ruined that for us forever.
Yeah, no, I know. I know. Anyway, thank you. And Amelia, thanks so much for inviting me to join this. It is a really interesting and very relevant topic. So I will jump in on the COPPA side of this. COPPA was enacted, decades after FERPA was. It was passed by Congress in 1998, in the days when the FTC would kind of submit a recommendation asking Congress to adopt legislation, and this law was passed 4 months after the FTC recommendation went up on the Hill. The original rule became effective in 2000. The Commission has tried to stay on top of these issues. It's been amended twice, and the most recent amendment took effect in 2013. So the primary goal of COPPA is to place parents in control over what information is collected from their children online. And the COPPA rule is the vehicle that the FTC uses to enforce the act. It's kind of interesting because, those of you who follow FTC issues know that the Commission frequently puts out guidance to business on how to comply with its various rules and laws. When they were dealing with COPPA, they issued a set of around 50 or so FAQs, and they continue to update these FAQs on a pretty regular basis, providing guidance on very specific questions that the FTC has received and how the rule applies to these kind of different scenarios. I think it is really a statement, the fact that the Commission is issuing and updating these FAQs, it's a statement about the fact that they understand how complex the rule really is. So I'm going to try and keep it simple, and as Amelia said, give just kind of the basics here. So COPPA applies to any websites, apps, or essentially any online service that's either directed in whole or in part to children under 13, or where the online service has actual knowledge that it's collecting personal information from kids under 13. There are 3 main requirements of the rule. The online service provider has to give parents notice and obtain their consent before collecting, using, or disclosing personal information from their kids under 13. The online service has to honor a parent's request to access or delete information that's collected from their children, and the service has to apply data retention limits and maintain reasonable security for the information that it collects from kids. Now, kind of very straightforward requirements, but as I said, it is actually kind of complex, and each of these requirements, as you kind of look into it, has a lot of kind of sub issues. So as I mentioned, COPPA applies in 2 scenarios. First, where there's actual knowledge. So when do you have actual knowledge? If an online service is a general audience site, but it has some kind of registration and asks for age information, and somebody signs up and indicates that they are under 13, they have actual knowledge that they're collecting information from a child. And then second, if it's directed to children, but it can be directed to children either in whole or in part. And to determine whether a service is directed to kids, the FTC looks at factors, the factors that I think you would expect. The subject matter of the service, whether it's using characters or activities that appeal to kids, like animation or music, whether there's advertising on it that's directed to kids, those kinds of things. The Commission will consider evidence of the actual audience composition, if that's available. And also, the Commission has set out, to make this even more complex, different compliance mechanisms for services that are directed primarily to kids and for services that target children under 13 as one audience, but are directed to other audiences as well. So for example, different compliance mechanism if you're directed to tweens, not 10, 11, 12, and also to young teenagers. COPPA only applies where there are certain types of personal information that's being collected by the online service, but it's a very broad definition. So name, address, email, screen name or username, a phone number, a photograph, video, or an audio file with the child's image or voice, geolocation, but its geolocation is further defined, so it allows you to identify a street name and the name of the city or town that the child is in, and any persistent identifier that's used to recognize a user over time and across different websites. And this would be, you know, like a cookie or an IP address that's collected by the online service. One of the key requirements of COPPA is that an online service obtains verifiable parental consent from parents. This basically means that an online service covered by COPPA has to notify parents first, both on the website, and that's usually in the privacy policy, and also in a specific direct notice that goes to parents about the data collection purposes. And the COPPA sets forth very specific content that has to be included in the direct notice. The consent has to be reasonably calculated in light of all of the available technology to ensure that the person providing consent is actually the child's parent. So it can't be something like sending an email to the child and saying, you know, forward this to your mom and get her to sign off on this. It has to be something that really is designed to ensure that the parent is the one giving consent. As I mentioned, there are also data minimization and parental access requirements in COPPA. But those are, I think, you know, kind of like the high-level requirements of the rule. And as I mentioned, it is pretty complicated. So again, I would be happy to answer questions towards the end.
Great, thank you so much, Lydia. You've explained that COPPA requires robust parental consent, but schools can consent in specific scenarios. The rule clearly wasn't designed to focus on the classroom setting. How did it come about that COPPA applies in this context?
Sure. So I think there was a gap. It was very likely that there was just a gap in coverage. You know, companies that aren't traditional ed tech, that aren't using traditional ed tech products, they're used more and more in schools. And I think what happened is the FTC was just getting a lot of questions about, you know, does COPPA apply in this situation? They didn't know that ed tech companies just weren't certain. And so what the commission did is it issued a set of FAQs on this subject. And the FAQs lay out how COPPA applies in the educational setting. So it contemplates that it's the school district that's entering into a contract with a third-party operator to offer online programs in the school. And, you know, the FTC, in fact, gives examples like homework helplines or online research tools or web-based testing services. So in these cases, and, you know, kind of instances like them, the schools are permitted to act as the parent's agent and can consent to the collection of kids' information on the parent's behalf only when the service is collecting personal information to be used only for an educational purpose and for no other commercial purpose, including advertising. You know, once it goes outside the limited educational purpose, the online service has to get parental consent. The operator is supposed to provide the school district basically with all of the notices that are required by COPPA. Obviously, a lot easier if you're just sending this to the school district. And if the school district asks, the operator has to provide a description of all of the information they collect and give the school district the opportunity to kind of see what they're collecting, gain access the way a parent would, and to request deletion. It's interesting because initially the FAQ that was issued by the commission kind of said that parents still had access and deletion rights in the school setting, but at some point when the FAQs were revised, that language was dropped. And now the FAQ just instructs schools to consider the feasibility of allowing parents to review the personal information. It's not that's collected. It's not an absolute requirement. And I think that although there was no explanation for this, I think it's just a kind of practical response. If schools are consenting to the collection of information, it's both confusing and I think pretty impractical for parents to be able to access and delete their kids' information. Generally, again, if companies are contracting with schools, the important part, a point to remember is that the information they collect cannot be used for any commercial purposes. They have to go to the parents to get their consent to do so.
Great. Thank you so much, Lydia. And again, if you have any questions, you can go to tinyurl.com/adtechedtech and enter those questions there. Let's turn over to state law now. Linnette, we've had 123 state student privacy laws passed in 39 states since 2013. Can you talk a little about how some of these state laws interact with advertising? And when it comes to ad tech, what are the states most concerned about?
Sure. Yes, it's been, we've had quite a flurry of state law activity over the past few years. And it can be really challenging to keep up with and to understand what they're looking at and how to, for vendors, how to operationalize across all the states, and for schools and districts, really how to hone in on what is of most concern with their state laws. And each state has its own twist on the matter, but there are some common threads, most of which we can trace back to FERPA and to FIPS, the Fair Information Practices Principles. And those are really common concepts around parents, or in the case of an eligible student, data subject control and choice over how the data is used, transparency, individual participation, being very specific about why the data is collected, not reusing data for another purpose unless we have individual choice and consent, collecting minimally required data, maintaining the integrity and security of the data, and having good, robust governance, behavioral practices in place to ensure that the data is protected appropriately. In addition, in the state laws, also quite present in the mix are concepts from COPPA, which was really created as a marketing limitation law. COPPA is a privacy law that was designed in large part, because of a reaction to advances in technology, where marketing to children was now able to be conducted online without that parent as gatekeeper. And so COPPA was designed to put the parent back in the driver's seat when it comes to what data is collected when marketing to kids and how it is used. And the state laws also include, I would say, some very tried and true reflections of, and this is probably not intentional, but some really tried and true scrutiny, concerns, and activity around advertising to children that I dare say harkens back to the dawn of Saturday morning cartoons. There is, as I often say, when it comes to compliance, everything old is new again, and there is nothing here that's not inherently predictable. The challenge is in the implementation, oftentimes. So the laws are different, but some of the common themes include restrictions on using student information to advertise to students, and in some states to advertise to parents. Prohibitions on profiling, gathering a profile on a student when that profile is not used for the school purpose. Reaffirming parent rights around control over their data, almost every state law includes what is essentially a reaffirmation of the requirements of FERPA, that parents have rights to consent to disclosure of their students' information, unless, of course, as Sara noted, the disclosure is done under very specific circumstances, such as the school official exception. So reaffirming that direct control over collection, use, and disclosure of personally identifiable information only for the school purpose, requiring deletion of data at the end of the contract. This is essentially a FIPS concept, a long-standing privacy concept, which essentially says, hold on to the data for as long as you need it, and when you no longer need it, you must delete it. And that is very much part and parcel of most state privacy laws, student data privacy laws, where the personally identifiable information is meant to be destroyed when it is no longer needed. No privacy law is complete without a really good, broad, vague statement about security and the requirement for reasonable security, which, by the way, includes deleting the personally identifiable information when no longer needed. And then transparency in the form of a prominently displayed, clear, easy to understand, accurate, truthful, comprehensive privacy policy, and accountability around the data. And we see, for example, in some states like Colorado, some additional concerns that are starting to get expressed in other state laws around things such as controlling data disclosure by vendors to their third parties, and ensuring that that data disclosure, that when the data moves downstream to a third party, that it carries the same protections as it did when the data was shared with the vendor, and some preclusions against it moving further. The model for all of this, or I should say the one that kind of kicked it all off across the states and was widely imitated is California's COPPA. And it really began the trend across the student data privacy landscape of directly regulating industry, as does COPPA, instead of educational institutions. COPPA is most widely imitated when it comes to the restrictions that it has on advertising, which prohibit, under California law, there's a prohibition against use of any information, including what it describes as covered information, which is personal information, which is gathered by, from, or about the student. It includes persistent unique identifiers to target advertising on any site or service, or using that information to target advertising off of the education site or service. Now, the challenge with some of these state laws is that what exactly is targeted advertising can be a little bit complex. There's a lot to unpack in the definitions of targeted advertising, which, the definition started with COPPA, but has been copied, adjusted, and refined in other state laws. And, I could spend a good deal of time talking about that, but for more, I would refer you to the Future of Privacy Forum paper that worked with Amelia on when she was at NASB on COPPA, because we do unpack the definition of targeted advertising a bit there. I think the important piece is that the definitions of targeted advertising across the state preclude use of a fairly broad range of student data that is personally identifiable. The states do not do us the favor of actually defining personally identifiable in any of their laws, but we should assume that it is a broad and wide definition along the lines of the FERPA definition. It does include the use of persistent identifiers and precludes us from using that for behavioral targeting. So, of course, this has a direct impact on the use of ad tech, which relies heavily on use of persistent identifiers. I should also mention that the laws also tend to preclude the use of information, including persistent identifiers, for that amassing of a profile about a student, except for a K-12 purpose. So this is another iteration of the preclusions that exist in COPPA and existing self-regulatory frameworks that preclude behavioral targeting to children and take them just one step further.
Great, thank you, Linnette. One more question for you. You touched on this a little bit, but how do state student privacy laws and COPPA work together? Are there any common threads?
There really are. Remember that under COPPA, the FTC acknowledges that unlike all other personal information, first of all, persistent identifiers are not considered personal information under COPPA. They do not require prior parental notice or consent to collect them when used only to support specific internal operations, including serving contextual advertising and capping the frequency of advertising. By contrast, most state laws include persistent identifiers in their definition of covered information, and as such, the identifiers may not be used for targeted advertising. However, what the laws don't do, as I mentioned, is actually define what is personally identifiable, and they don't take into account that persistent identifiers come in several formats and serve a variety of purposes, including many that are for the convenience of the user, allowing for customization of content, retaining progress on a product, serving ads, and also to ensure that a user doesn't see too many ads. We use persistent identifiers to cap the frequency of advertising. We use persistent identifiers to ensure that individuals see ads that are appropriate for them. And so there are some questions in there as to whether or not prohibiting a third grader from seeing an ad that is intended for a high school student, or to put it another way, to ensure that the third grader only sees ads intended for the third grader would be considered targeting and thus precluded by some of these state laws. So there's a little bit of murkiness in there, but I would say that one thing we do understand is that we cannot use any student information, including the persistent identifier, to target advertising. And I think we should look at targeted advertising with a very broad brush. So it's very important to understand when looking at your third parties operating in your product, and for schools and districts to understand when looking at education technology, first of all, that not all third parties are created equally, and that the presence of a persistent identifier being collected does not mean that targeting is happening. But also to remember that just because your advertising technology is on a product or is in a section of a product that is not targeting students under the age of 13 doesn't mean you're home free, because state privacy laws restrict use of information from or about the student to serve targeted advertising to all K-12 students, and in some states to parents. So it's important to understand exactly how your ad tech lines up in compliance with COPPA, state student privacy laws, GDPR if you're operating on a global front, FERPA, PPRA, all of it. So to that end, critical to understand the type of identifier present, the business model of the company serving them, what type of service they're providing to you as a vendor, what service they're providing to others for which they might use your data, and ensure that you have the contractual protections that preclude that, and ensure that the data is only used for school purposes. So this often means crafting agreements well outside the scope of ad tech standard terms. However, I think we should take heart in knowing that the ad tech companies don't want to be caught up in any of this, and many of them will readily tell you how they can and cannot comply. Also keep in mind that many of them are familiar, many of these ad tech companies are familiar with COPPA, but not with state student data privacy laws or with FERPA. So you'll be responsible for providing them with that education. And I would say also make sure that when you are working with your ad tech provider that you're working with the right person there. I often say you may start with a sales contact, but don't end there. Make sure you're working with the individual at your ad tech company who really knows, the legal team, because you're responsible for probing and ensuring that they can provide, I guess, what GDPR would call sufficient guarantees of compliance. As I mentioned, this restriction on ad tech in state privacy laws, again, unintentionally, I think, follows some 60 years of regulatory scrutiny and restrictions on advertising to children. Children are afforded special protections as a vulnerable population. From a developmental perspective, they simply don't have the abilities to distinguish between ads and content to understand the persuasive intent of advertising. So if we take COPPA as an example, it was intended as a restriction and form of parental control around marketing. And what we're seeing is the state student privacy laws are kind of latching on to those same concerns. Unfortunately, I think they're just probably not using knowledge of that landscape to define their terms and to define the scope of what is of concern when it comes to ad tech. So the implementation can be a little bit complicated as a result. But I think with every iteration of a state law, we get a little bit more refinement in these areas.
Absolutely. Thanks so much, Linnette. Before we turn over to the technical and practical best practices side, a couple follow-up questions for all of you on the laws. So first of all, Sara, can you talk about what enforcement actions the department can take if a provider discloses student PII in an impermissible way according to the contract between the school and the provider?
Sure. So the folks generally know that FERPA comes with a pretty heavy hand if a school violates FERPA. If we find that a school violates FERPA and they refuse to come into compliance, the department may withhold federal funds from the school. But if it comes to a point where a school shares information with in the case that we're talking about, an ed tech company, another one could be a school volunteer or somebody or another person is working with the schools, a third party working with the schools. If it is found that that third party mistreats the data or misuses the data or uses the data in a way it was not, it is not allowed to use the data, the department actually may impose a we call it the 5-year rule ban, and we can ban the school from using that ed tech company, the provider, for a minimum of 5 years. And that would mean that the school may not share data, any information from a student's education records with that company for the period of time that we decide is necessary.
Great. And then going back to Linnette, Linnette, I know you also do a lot of work with COPPA as well. Can you break down the recent COPPA enforcement actions that implicate ad tech?
Sure, absolutely. There have been some very interesting developments in enforcement around ad tech that actually happened in New York State. Attorney General Eric Schneiderman, his office had been engaged in a 2-year investigation into third-party tracking technologies on a variety of websites. I think important to remind everyone that COPPA is enforced not only by the FTC, but the states also have enforcement rights around COPPA. And so there are some states, including New York, that are very active there. So there were 4 players that were caught up in this investigation: Nickelodeon, Mattel, Hasbro, and Jumpstart, which owns Neopets, formerly owned by Viacom. And all told, they ended up with financial penalties of about $835,000, and were required to adopt comprehensive reforms to protect children from improper tracking, including regular web scans, such as a proxy analysis to reveal third-party targeting, updating their third-party vetting policies and procedures, which, by the way, are already required under COPPA. And 3 of the players, Nickelodeon, Mattel, and Jumpstart, need to, in the wake of the settlement, provide regular reports to the AG's office on the results of their new scanning services. Hasbro participated in a safe harbor program, so there was no financial penalty for Hasbro there, but important to note that the safe harbor did not protect them from enforcement entirely. They were off the hook in terms of financial penalty, but they are on the hook for all the other aspects of the settlement. So what happened essentially was a couple of things. I'll talk about Nickelodeon first. What happened was a lot of advertisers and agencies that were placing advertisements on the Nick Jr. and Nickelodeon websites introduced tracking technologies of third parties that engaged in the type of tracking and profiling and behaviorally targeted advertising that's prohibited by COPPA. We often say that when working with regulators, they like to see some good faith. They like to see that you've been working on compliance. And it sounds like what we can glean from the information is that Viacom did say, listen, we're working on it, we're trying to mitigate the risk, but in the eyes of the AG's office, Viacom didn't act quickly enough to implement those safeguards. In addition, some visitors to the homepage of the Nick Jr. website, which is intended for preschoolers, were served behavioral advertisements and tracked through a third-party advertising platform. Viacom argued that the homepage of Nick Jr. was parent-directed and thus not covered by COPPA, but the design of the site suggested otherwise. And remember that determining directedness to children under COPPA is a sniff test, or I refer to it as a sniff test. It's a totality of circumstances test on a variety of factors, including the look, the feel, the sound, the marketing of the site. So they were caught up in that. Mattel had third-party tracking supplied by a third-party data broker. Mattel was using, and this is probably the most common misstep, Mattel was using the tracking for basic site analytics, number of visitors, all completely fair game. However, the tracking technology supplied by the data broker introduced many other third-party tracking technologies that engaged in behavioral targeting. In one case, Mattel puts videos on YouTube. They had embedded some of their YouTube videos onto their child-directed website. I say this all the time, the YouTube player, when embedded on your site or service, is not compliant. It comes with Google tracking technologies, it comes with social media tracking technologies, and those cannot be stripped out. So it cannot be used as an embedded player on child-directed sites. Jumpstart had a situation with Neopets, which was also serving improper third-party tracking technologies, both for users who were logged in and indicated that they were under age 13 and users who were not logged in. So a situation where they would know that a user was under age 13, but the configuration of the tracking technologies did not change depending on the age of users. Jumpstart had also integrated a Facebook plugin into the Neopets site. Plugins, and many plugins, include tracking technologies even if you do not kind of click on the icon. So critically important to understand how your third parties operate, what exactly are you embedding into your product. Hasbro's misstep was a remarketing campaign in on their Nerf website, section of their website. They served advertisements to users. They integrated a plugin that allowed users to be tracked across their website and introduced third parties that engaged in behavioral targeting. And what they did was they served ads on their Nerf section of the website, and users who engaged in those ads were then served ads on other websites at a later time, right? So that's online behavioral advertising. It's a remarketing. When you record who has clicked on an ad and you use that information to serve them another ad somewhere else on another site. And so these parties are all engaged in settlements with the State Attorney General's office and were required to adopt comprehensive reforms, including, as I mentioned, the regular scanning, new procedures for vetting third parties before they're introduced to determine whether and how the third parties collect, use, disclose, and allow others to collect, use, and disclose information. Critically important and something that everyone should be doing with their third parties. Updating their website privacy policies. And, you know, essentially what the AG said was these website operators were not sufficiently vetting their third parties, were not monitoring their sites for third parties that might be spawned by the third parties that they had in place. We know from a conversation in the last call we had on the subject, third parties are not just dormant. They can bring other third parties onto your site or service without your knowledge. So a lot to keep track of in this rapidly changing ad tech ecosystem to ensure COPPA compliance. It should be noted that after this, the Attorney General also had issued a settlement with the Safe Harbor for not that had worked with Hasbro for what the AG said was failing to adequately prevent the illegal tracking technologies. So the Safe Harbor was also on the hook with the Attorney General's office for the work that they had been doing or had not been doing.
Great, thanks, Linnette. And along those lines, one of the reasons we decided to hold this call is that we've heard that the FTC is starting to contact specifically education technology companies about advertising trackers on their websites. Before we turn things over to Bill to talk more about the technical and privacy policy side of this, Lydia, do you think we'll see an increase in COPPA enforcement in this area?
So it's a great question, and we are seeing that the FTC is very active in COPPA enforcement generally. As folks on this call may know, the Maureen Olhausen, who is currently the acting chairman at the commission, recently put together an internal task force on privacy and harm, and she, her kind of focus there is trying to bring some economic analysis into the commission's privacy enforcement strategy. But it's interesting because she also said that that kind of cost-benefit analysis isn't as relevant to COPPA because first, it's a statute, and there are clear statutory requirements, and the commission really doesn't need to prove kind of harm to show that there's been a violation. And second, and this, Linnette mentioned this, but this is absolutely true, the FTC has always considered data about children to be particularly sensitive. And, children and advertising is just kind of like the third rail for the commission. It is, the agency is much more willing to go after actors who may be misusing children's data, and frankly, who may be using children's data for advertising in violation of a particular rule. The fines for COPPA violations have jumped dramatically in the past couple of years. They've gone from $16,000 to over $40,000 per violation. And so it is even more, it is difficult to go through an FTC investigation. It is unpleasant to be under an FTC order, but it can also be an expensive proposition. I would say that for all of these reasons, I think we'll see a lot of commission interest in this area. I think, COPPA is something that the agency has long been interested in, and as ed tech becomes a more significant player, they will absolutely get involved in this space.
Great, thank you so much, Lydia. Turning things over to Bill Fitzgerald from Common Sense Media now. Bill, you spend a whole lot of time looking at privacy policies and recently have been looking into a lot of these ad tracking questions. So to kick us off, what do you frequently see about advertising when reviewing privacy policies, and what could be a flag in a policy for school districts?
Well, in reading through policies, there really is like a pretty broad spectrum of how it's treated. Like there are some policies that are actually very clear about what third parties they use and what they do, and they list them out individually. They describe they describe what each third party does. They describe the data that's actually handed over to the third parties, and they also actually go into limitations about what they can do with the information based on the kind of the purpose of the actual third party. And that when I see something like that in a privacy policy, that's a very positive sign, because that's indicative that the vendor is really clear about what their technical stack does, and is also really clear about their business plan. On the other end of the spectrum, we will often see very little to no information about third-party usage or any limits on what third parties can do with information, regardless of whether it's actually the presence of a third-party tracker on the site or information that's shared with third-party vendors that support the operations of the site. And from my perspective, those are two very different things, two very different use cases that are most accurately described with different information about how they can use the information. So those are, when I'm reading a policy, that's what I look for on the policy side. And clear information is generally a good sign. A lack of information or unclear or contradictory information is a flag that a school or district should look for.
Great. Now, getting into the more technical side, what does it mean if there's a third-party tracker on a site or service?
At the most basic level, like when you see a third-party tracker on a site or service, that's pretty much all it means. Like, hey, there's a third-party tracker here. It's doing something. And in and of itself, the presence of a third-party tracker doesn't tell you all that much. And that's where referencing, I will, when I see a tracker in a site that I'm evaluating, I generally triangulate three things. The first thing I look at is actually what the tracker is. I actually look at what the tracker is doing, and because I'm usually looking at this through either a cookie manager or an intercepting proxy. The intercepting proxy is a really useful toolkit that lets you look at all the traffic between the browser, between your browser and the service and any third-party calls. So when I say an intercepting proxy, we can understand that as a more detailed view is, with what's happening in the interaction as the user is working in the app. I triangulate what the cookie is actually, or what the tracker is actually getting. And when I say tracker, I mean either tracking JavaScript or a tracking cookie. I'll use those interchangeably most of the time. I'll cross-reference what it's doing against what the privacy policy says. And then I'll also take a look at the URL that the third-party call is going to and see how easy or how difficult it is to actually identify the company. Generally, the more vague and difficult it is to identify who owns a URL that a tracking call is going to, that's generally a sign that more research is warranted to actually understand what's going on. With all that said, the presence of a tracker really, on its own, as a piece of isolated information, should not be taken as any indication that something nefarious or potentially out of compliance is going on. It's really a sign that more questions need to be asked.
Great, thanks. And what doesn't it mean if there's a third-party tracker on a site or service? You got into this a little bit, but if you have anything to that.
Yeah, no, I kind of veered into that. I mean, when looking at basically how a site or how a vendor respects the privacy of the people using the site, like the presence of a tracker doesn't indicate tracking. The absence of a tracker doesn't indicate the absence of tracking, if that makes sense. Like there's still a lot of ways behind the scenes if a site or service collects enough information where it could actually be leveraged completely outside the view of any intercepting proxy, like of any technical tool that gives us a small window into what a service does. So this is why triangulating the privacy policies of the service, kind of the rough business plan of the service, like there are significant differences between services that are offered to schools or districts free of charge, compared to services that have a subscription fee. Services that offer free accounts versus services that only own pay accounts. Like that's actually something I consider when I'm looking at trackers and evaluating that piece. So again, just as the presence of a tracker doesn't necessarily indicate that that anything nefarious is going on with somebody's data. The absence of a tracker doesn't also indicate that everything's fine. These are all observations that need to be triangulated against really the business plan of the service and how the service charges or doesn't charge for people accessing it.
Great, and you started to touch on this. Why isn't blocking cookies enough to stop tracking?
Yeah, so this is, one of the, it's really easy to talk about, PII and have that be kind of the focal point of what we talk about when we look at privacy. But there are a range of ways that we can be tracked and actually uniquely identified without any personal information. And one of these, one easy example is browser fingerprinting. And when you look at the requests that are made between a user's browser and the service, every single request includes information about the operating system, the browser you're using, the version of the operating system, the version of the browser. And it's a real simple step to go beyond that. And, there's, canvas fingerprinting is a method that will actually draw a small image on your, in the background, and then you can actually track, basically different computers with different processors will draw that in slightly different ways, and that actually can be used to uniquely identify somebody. There are some systems that will actually that will collect up the plugins that you have. Others that will actually collect up the fonts you have installed on your system. And these are all things that can contribute to a very accurate identity of an individual over time. And if you compare something like that with an IP address, you can start to actually be very accurate with predicting who an individual is, to the point where you could probably infer identity even if you were given no information about their name. So blocking cookies won't touch any of that. This is why, when I see calls to third-party JavaScript, one of the things that I commonly do in that is, and some of these calls are huge, like they're 10,000, 20,000 line chunks of JavaScript that get loaded on a website. You just look at what can be exposed in the HTML5 spec and do searches for some of those terms within the JavaScript, and you can actually have like a 300 line chunk to start evaluating. But you can get a sense of what specific characteristics are being asked for. And a lot of times it's actually browser fingerprinting technology that can be used to identify somebody. And within a consumer setting, it's not really, that's how ad tech works. But within an ed tech setting, it's often a more circuitous explanation to explain how the collection of that information helps further any educational purpose.
Great. And one last question for you, Bill, before we go back to sort of best practices. How can we cross-reference the trackers we see to what is disclosed in privacy policies in terms of service? From a vendor perspective, what I strongly recommend, and what is really, in school districts, when they are evaluating a service, they really appreciate a thorough list of the third parties that are used in a service. And it's a kind of thing where, somebody with an intercepting proxy can get that third-party list within about 5 minutes, because all they need to do is basically log in to the site and see what third-party calls get made after hitting 10 to 15 pages. That's usually fairly comprehensive of the third parties that are used, and that's your list of third parties. And if the list of URL calls you see via the proxy line up as close to one-to-one as possible with a list of third parties that are disclosed in terms, that's a really good sign. That shows, again, that the vendor really controls their stack and understands what's happening within their system. Linnette mentioned this a little bit, and this is something that I can't highlight enough because I see this very, very frequently, is there are some ad tech providers who will chain multiple requests together. And these chains actually shift over time. So unless a vendor is actually actively monitoring what third parties get called, it's possible that there could be tracking on their service that happens because of a technical decision made by an ad tech vendor that is outside the scope of what the ed tech vendor wanted. It could potentially get the ed tech vendor into hot water. So that's where,
if you do use an ad tech provider that chains requests together, monitoring what those are and having direct contact with the person at the ad tech company would be really important. I think, I forget who made the recommendation, but it was, to make sure you're not talking to your salesperson, talk to your legal person. I would actually recommend getting a technical lead as well as a legal lead, and making sure that the technical lead and the legal lead are saying the same thing. Because there's often a disconnect between what each of those silos within a company will understand.
Great, thanks, Bill. So going quickly through each of you, Sara, starting with you, what are some of the steps that both ed tech companies and schools should take to manage their responsibilities around advertising technology?
Oh boy. So review our guidance. We have our protecting student privacy while using online educational services, both our best practices and also our model terms of service that can kind of help you get in the, understand the basics of FERPA. NPPRA, and also the model terms of service. I was just going to link to that on the Google Doc, but that goes through some best practices and some clauses to avoid when you're reviewing these terms of service that for apps or other things that might be used in the classroom and come in under a quick wrap agreement or something like that. And then also, folks can always contact us. I added the link, I think it's number 7 on the potentially useful resources, a link to contact us with any questions on FERPA, PPRA, general best practices. If you're generally feeling overwhelmed, you can feel free to reach out to us and we will get back to you. Typically we jump on a call to talk through issues that folks are having.
Great, thanks, Sara. Lydia, same question. What are best practices that you recommend?
Sure. Well, first off, Sara, I'm going to make sure that that I get your number. From the COPPA perspective, I think, kind of practically speaking, if schools are entering into contracts with ed tech companies, and they need to make sure that they're getting the right information, and I think that they should really follow the best practices that are recommended by the FTC. Kind of like post a notice on the school district's website that parents can see and understand all of the ed tech companies that may be that are approved for use in the school district and the nature of the information that they may be collecting. I actually think there's one issue that we didn't really touch on, and I think it gets more complicated, so I'm just going to kind of raise it. What happens when an app is used by a teacher and not by the school district? That can be much more complicated, and teachers may not be all that savvy on how to operate in a way that's compliant with COPPA, and so or with FERPA. And so one of the things that I would certainly recommend is that school districts train their teachers on these issues so that they understand what the requirements are when they're bringing apps into the classroom.
Great. Linnette, same question.
Yeah, I think, areas where I see schools struggling the most is around understanding how to ensure that the ecosystem of apps and websites that they are bringing into their school systems are vetted in any way to ensure compliance with COPPA and FERPA and the state privacy laws, to understand that when your teachers are bringing products into the classroom and clicking on an agreement, that is a contract. Copy and paste it, print it out if that helps to bring that concept to life, to say it is a paper contract, but it is, and you're binding your school, or your teachers are, whether they have the authority to do so or not. I would say I also see schools and districts focused in large part almost predominantly on security and not on privacy, and understand that they are distinct but related disciplines, and it is the behavior of privacy governance that really requires more work in schools and districts, because, you know, even when we think about security, if we look at the causes of breaches in the education sector, it's almost predominantly human error. It's almost predominantly the behavior that fails, not the technology. I would also encourage, in addition to PlayWell, I'm project director for COSIN's privacy initiative. I would encourage folks to take a look at the privacy toolkit that we issued earlier this summer. It's new and expanded with tons of information and practical application guidance on FERPA, COPPA, PPRA, how those laws work together. You know, so how to unpack all of those laws when looking at a piece of technology. And I would say, you know, start where you are. It is a big project to bring technology into the school system and to understand how to operate within these laws. Any little thing that you can bite off, you should deem as successful and just keep at it.
Great. And Bill, last word before we turn to questions. What are some best practices on your end?
Well, yeah, I mean, first off, all of the suggestions that everybody just made, like, do those. They are all great suggestions. Second, on, again, whether you're a vendor, whether you're a school district, run your software through an intercepting proxy and see what turns up. For people who kind of want to get started on kind of learning how to do this, we've actually written up a guide to do this. It's listed in the resources, but also on the Common Sense site, we have actually shared out the exact toolkit we use when we're evaluating. We have documented our triage process. We have published our entire question set online. Our question set is actually mapped to FTC guidance, state, primarily federal privacy law, some state privacy law, and data handling best practice. So every question that we ask, the overwhelming majority is mapped to the specific rationale behind it. So it's actually a pretty good tutorial for how to actually evaluate and how to see kind of what's at stake in a different application. But these tools are all, again, they're all there. They're all freely available. They're all released under an open license. So I strongly encourage anybody who wants to take them and use them.
Great, thanks, Bill. So before we get into the Google Doc, we are going to stop recording. So give it a pause for that.